Good evening. I'm Leonard Baines, Dean of the University of Houston Law Center, and I want to welcome you to the Yale Rosenberg Lecture. It's an annual lecture that we have on really important topics. And today we're going to be talking about Constance Baker Motley, our first Black federal district court judge. If we couldn't have planned it better to have this conversation on the second day of hearings of the potential first Black female Supreme Court justice. And so we have really great presentations from outstanding scholars and others who will be talking about these issues today. But at first, I want to talk a little bit about Yale Rosenberg and the lecture series itself. So let me show you some slides of who the past speakers were, among other things. Hold on. So let me cue it up. Slideshow. In the beginning. So this is a Yale Rosenberg Memorial Lecture. Yale Rosenberg was an alumnus of Rice University. He graduated in 1964 from NYU Law School, where he was a Root Tilden Scholar. He joined the University of Houston Law Center faculty in 1972 to pursue his true calling of teaching after a distinguished career in government. He inspired instruction in civil procedure, federal jurisprudence, jurisdiction, professional responsibility, and Jewish law. The Law Center earned the UH Teaching Excellence Award in 2000. He's an award-winning scholar, and he was called America's prophet for his analysis of the end of federal habeas corpus. He was joined in marriage and in his career with Irene Merker Rosenberg. They had a great love for each other. They were on faculty for many, many years and collaborators and had 30 years of marriage. And after Yale's death, after his passing, Irene established this memorial fund to recognize excellence at the UH Law Center, but also recognized her deceased husband. This lecture series and the support also provide a student writing prize and also allows for distinguished speakers to come and speak in Law Center at a variety of different topics. Previous speakers have been Professor Samuel Levine, who's now the director of Jewish Law Institute at Touro Law School, Professor Joshua Dressler, who's a professor emeritus at Ohio State University, Moritz College of Law, our own Professor David Dow, who's the Cullen Professor of Law, Cornell William Brooks, who's now a professor of practice and of public leadership at the Harvard Kennedy School. At the time, he was president of the NAACP. Our own Professor Renee Kanaki Jefferson, who's professor of law, and the Joanne and Larry Doherty Chair in Legal Ethics. Professor Gabriel Jack Chin, who's the Edward Barrett Chair of Law, and the Martin Luther King Jr. Professor of Law at UC Davis Law School. Professor Tanya Hernandez, the Archibald R. Murray Professor of Law at Fordham Law School. Professor Nelson Tebby, the Jane M.G. Foster Professor of Law at Cornell Law School. And tonight we have our speaker, a very noted speaker, Professor Tomiko Brown-Nagin at Harvard Law School and Dean of the Radcliffe Institute. Let me stop sharing my slides. And let me also acknowledge several others who are been very supportive of the Rosenberg Fund. Certainly, I have to acknowledge his sister, Elsa Thibault, his cousins, Leslie Wagner, and his sister Robin Wagner, who are cousins of Yale. Shirley Cooper and her daughter, Toby Cooper, also cousins of Yale. Iris Lubin, who's a cousin. Rivka Sayarat, who's the grandeur of Yale, and Irene Rosenberg. Jerry and Linda Payne, Jerry's lifelong friend of Yale from preschool, and both are dear friends. Linda is retired lawyer from Chamberlain Herlica, Judge Abraham Sofer, and of course, our own Professor Emeritus, Laura Oren, and Professor Maris, who were lifelong friends of the Rosenbergs and are very, very involved in this programming. So let me now introduce our speaker, our guest speaker, our keynote speaker, Tomiko Brown-Nagin. And hold on, while I pull up her bio. 1 second. End the slideshow 1 second. Close that. There we go. So Tomiko Brown-Nagin is the Dean of Harvard Radcliffe Institute. Daniel P.S. Paul, Professor of Constitutional Law at Harvard Law School, and a member of the History Department of the Harvard Faculty of Arts and Sciences. She's an award-winning legal historian, an expert in constitutional law and education law and policy. She's a member of the American Academy of Arts and Sciences, the American Law Institute, and the American Philosophical Society. A fellow of the American Bar Foundation, a distinguished lecturer for the Organization of American Historians. She has published articles and books on a wide range of topics, including the Supreme Court's equal protection jurisprudence, civil rights law and history, the Affordable Care Act, and education reform. Her 2011 book, Courage to Dissent, Atlanta and the Long History of the Civil Rights Movement, published in Oxford, won 6 awards, including the very prestigious Bancroft Prize in U.S. History. Her latest book, Civil Rights Queen, Constance Baker Motley and the Struggle for Equality, published by Pantheon in 2022, explores the lives and times of Constance Baker Motley, a path-breaking lawyer, politician, and judge, as I noted in my initial remarks, the first African-American women federal judge. Professor Dean Brown-Nagin was appointed chair of the Presidential Committee on Harvard and the Legacy of Slavery, which is anchored at the Radcliffe Institute. Brown-Nagin has previously served as a faculty director of Harvard Law School's Charles Hamilton Houston Institute and as co-director of Harvard Law School and the History Program, among other leadership positions. She's earned her law degree from Yale University, where she served as editor of the Yale Law Journal. She has a doctorate in history from Duke University and a BA in history summa cum laude and Phi Beta Kappa from Furman University. In 2016 and 2017, the Joy Foundation Fellowship, she held a Joy Foundation Fellowship at Radcliffe Institute for Advanced Study and became Dean of the Institute on July 1st, 2018. Join me in welcoming Dean Brown-Nagin.
Thank you, Dean Baines, for that introduction and for the invitation to deliver the Yale Rosenberg Lecture at the University of Houston. I'm delighted to be with you and to appear on such an illustrious panel of experts. And I am thrilled to talk about my book, The Civil Rights Queen, and especially so as we experience the historic confirmation hearings of Judge Ketanji Brown Jackson, who of course is the first Black woman nominated to the US Supreme Court. It is a timely moment to reconsider the life and legacy of Constance Baker Motley, who is the first Black woman ever to serve as a federal judge. And of course, in her remarks, when she was nominated by President Biden, Judge Jackson said that she stands on Motley's shoulders. And sure enough, the history of the two women, the histories are entwined. And I am delighted to speak about Motley at this moment, along with offering some reflections on the judicial role. I am looking forward to also having some conversation with the panelists and with the audience. First, however, I'm going to provide an overview of Motley's life and work. I'll briefly read a passage from the book about her confirmation process, conclude with some thoughts, as I mentioned, about the judicial role as it relates to Black judges, and then we'll have some time for discussion. Now, the title of my book, Civil Rights Queen, is taken from a journalistic account about Motley, and it captures how unique she was. She fascinated people because few people had seen a Black lawyer, much less a woman lawyer, much less a Black woman lawyer. All of those things together made her the civil rights queen. She was extraordinary. in this combination. And she was fascinating to me, in part because she lived such a long and full life that consisted of 3 different professional roles. And I was interested in the question of how her social justice commitments found expression in each of those roles. In phase 1, she was a civil rights lawyer. Even before she graduated from Columbia Law School, she had landed her dream job, and that was at the NAACP Legal Defense Fund, where Thurgood Marshall hired her in 1945 on the spot. She worked at the Inc. Fund, as it's also called, for 20 years, during which time she was the only woman lawyer. And under those circumstances, during her long career at the Inc. Fund, Motley developed a reputation as an excellent lawyer. She argued and won 9 of 10 cases at the US Supreme Court. She helped litigate one of the most important cases in 20th century constitutional law, that's Brown versus Board of Education. She then desegregated school systems in Atlanta, Savannah, New Orleans, Nashville, Mobile. And of course, because of these efforts, thousands of students were able to have a more equal education. She then went on to co-counsel cases that desegregated higher education in the South, including the University of Alabama case, which occurred in 2 phases, the University of Georgia case on behalf of Charlene Hunter Galt and Hamilton Holmes, and Ole Miss, which she called the second battle of the Civil War, and like a war, resulted in death, in the violent backlash surrounding Meredith's entry left 2 men dead. She also represented the Birmingham children's marchers who had been attacked by Bull Connor's officers during protests against segregation, and ended up filing a case after those children were ejected from school by the school superintendent, that really worked to save the momentum of the civil rights movement in Birmingham, which of course was a landmark campaign. And so, as you can see, her job extended far beyond the 4 corners of her law office. In fact, in service of the Inc. Fund's battle against Jim Crow, she traveled to dangerous places, as I describe in my book, often to rural backwaters where she faced hostility from whites. And a part of the story that I tell is about how she experienced humiliations, race and gender-based, while she did her job. Lawyers refused to call her Mrs., the honorific, which was so important. They called her that Motley woman, or referred to her only indirectly as her or she. And it was not only lawyers who disrespected her. Motley once endured a hearing before a federal judge in Birmingham that began with his observation, "Well, you're a woman." In other words, questioning her right to be in that courtroom. And so while she was seeking dignity and equal justice for others, for her client, she was really doing so for herself as well. But she didn't stop there. After this brilliant career as a civil rights lawyer, she made history in politics. In 1965, New Yorkers voted her Manhattan Borough president. She was the first female to hold that position. And prior to that, she had been elected to the New York Senate as the first Black woman to sit in that chamber. Then in 1966, President Lyndon Johnson appointed her a federal judge. When she won confirmation to the US District Court in Manhattan, she became the first Black woman ever appointed to a judgeship, and only the 5th woman ever appointed to the federal bench. So she was a truly remarkable figure who helped to change the legal architecture of this country through her extraordinary accomplishments. And thus, this book is not only a biography, it's really a story about change in 20th century America, told through Motley's life and work. She embodied and also made social and legal change. And I do assert in my book that she stands alongside her mentor, Thurgood Marshall, as a symbol of the Second American Revolution, and joins her client, Martin Luther King Jr., as the personification of America's struggle to overcome slavery. The exclusion of her from our histories and as prominent of a role as she deserves is a kind of historical malpractice. Now, in addition to the overarching aim of making her name central to American history, the project also seeks to yield insight about social change and the judicial role. When Motley was appointed to the bench, civil rights and women's rights groups were overjoyed as if they had seen the promised land. Activists assumed that with one of their own on the bench, she would surely be able to advance the struggle for equality, as Motley was a part of the very first wave of jurists in what we now call the push to diversify the bench. And so a part of this book is considering, in light of her 39-year career on the bench, how she sheds light on the risks and the rewards of that project. And now I want to read a little bit from the chapter of my book about her confirmation proceedings as context for discussing both those risks and rewards. And here is the passage or passages that I'll read. It begins that despite the perfect optics of the day at the White House when Motley's confirmation was revealed, nomination was revealed, it concealed what was happening behind the scenes. Motley's stellar record as a civil rights litigator and her prominent role in New York politics had not insulated her nomination from criticism, and the confirmation process proved arduous. Ironically, it was Motley's famed career as a civil rights lawyer that slowed her bid for confirmation. Wielding the power of his chairmanship of the Senate Judiciary Committee, Senator James Eastland held up Motley's nomination for months. A wealthy plantation owner known as the voice of the South, Eastman defended white supremacy from the floor of the US Senate. He was adamantly opposed to Brown versus Board of Education, which he said had destroyed the Constitution. He was not going to let the nomination of the Black woman civil rights lawyer who desegregated his alma mater, Ole Miss, slide quietly to confirmation in the Senate. Practiced in the tactics of delay and obstruction, Eastland had led Senate opposition to the judicial appointment of Thurgood Marshall, Motley's former boss. But Eastland's efforts to block Motley's appointment as a federal judge backfired. President Johnson did not pull Motley's nomination. Numerous respected legal and political heavyweights remained in Motley's corner. The New York senatorial delegation stood behind the nomination. And so on August 30th, 1966, after a 7-month delay, the Senate confirmed Motley's appointment as a US district judge over the objections of the powerful Senator Eastland. And so she had achieved her most impressive feat yet. A White House memorandum announced Motley's appointment with a one-word header that simply said, "First." Constance Baker Motley was the first Negro woman ever appointed to a federal lifetime judgeship, read the memo, and the appointment symbolized, the memo said, that the Negro is on his way and that the doors are opening on every side. And you should be able to see on the slides both Motley in her Black judicial robes and what she was facing, which was literally being surrounded by men, white men, when she took her seat on the bench. So now the question is, what happened once she ascended to that powerful position? Well, once she was a sitting judge, Motley sometimes ruled as opponents like Eastland had feared, issuing landmark rulings implementing the civil rights ban on sex discrimination in employment, for instance. but overall, Motley did not issue reflexively liberal opinions. In fact, the conclusion that I reached in my book about her is that although she was a political liberal, she is best understood as a judicial pragmatist. She did render some decisions that were important and that opened up the professional workplace to women, including in the law, in law firms. But Motley's record shows that the commonly held assumption that race or a civil rights background in and of themselves affect life outcomes is oversimplified and reductionist. And I want to say that those who know the scholarship on race and judging and on gender and judging will be unsurprised by the fact that this great African-American jurist was hardly a radical on the bench. That scholarship tests the notion that judges yield substantive instead of symbolic representation for the communities that they are thought to represent. So studies have not shown a significant difference in the voting behavior of white and non-white judges. For example, Black district court judges do not decide cases differently than white judges and do not support Black issues more often than their white colleagues, nor does the presence of Black judges on appellate panels lead white judges to issue decisions more favorable to African Americans. Moreover, Black district court judges do not rule in favor of criminal defendants more often than their white colleagues. One study found a racial impact in criminal cases, but in the opposite direction of the expected one, that Black district court judges actually imposed harsher criminal sentences than others. The reality is that judging is mediated by numerous factors. Some factors are internal to the law, some are external. The internal factors are precedent, stare decisis, which powerfully constrains judges, even it should constrain the US Supreme Court, ensuring incremental change only. Then there is professionalism, institutional norms that impose constraints, including a desire to be respected and to be promoted. And I want to emphasize that Black judges are likely to be especially sensitive to these norms. In pursuit of professional respect, judges subjected to identity-based scrutiny, as these judges often are, might be especially careful to demonstrate competence and impartiality and to avoid using their discretion in ways that smack of ideological bias, particularly in cases with a racial dimension. And I want to note that the recusal motions that Motley and many other Black judges were often subject to make this point. I want to tell you about a sex discrimination case that was filed against Sullivan and Cromwell by several female law school graduates in 1975. Motley drew the case that alleged that the firm systematically discriminated against women in employment, and the firm's attorney protested. In personal correspondence that he sent to the judge and in a formal motion, the judge requested that Motley recuse herself because, and I'm quoting, as an African-American and a woman, she likely had experienced workplace discrimination. He also cited a past statement that Motley reportedly had made regarding the crippling effects of discrimination, and said that given her identity and her experiences, Motley would too strongly identify with women who alleged discrimination. And I'm quoting again, "I believe you have a mindset that may tend, without your being aware of it, to influence your judgment." London argued by implication that only white men could properly preside in a Title VII sex discrimination suit. Well, Constance Baker Motley would not remove herself from the case. After she analyzed the Black letter law on judicial recusal, Motley directly addressed the heart of London's allegation. She said, "It is beyond dispute that for much of my legal career, I worked on behalf of Blacks who suffered racial discrimination. I am a woman, and before being elevated to the bench was a woman lawyer. But she said, these facts themselves did not arise to the level of bias within the meaning of the relevant law. And she held, if background or sex or race of each judge were by definition sufficient grounds for removal, no judge on this court could hear this case. In other words, she turned this argument on its head and said that all judges have a race and a sex, and that she, as a Black woman, would not be turned away from this case on that basis alone. It was a brilliant opinion. In fact, it's one of the best known opinions of her 39 career on the bench, and I want you to think about that. One of the most notable opinions by one of our most celebrated Black judges is, in essence, defending her right to be a judge, and in cases that related to discrimination and to race, which is why I argue in my book that being the civil rights queen was a double-edged sword. And I should emphasize that Motley was hardly alone in having her background weaponized against her in this way. Black judges frequently have been targets of motions for recusal on these grounds. It also is true that judges, women judges, have been subject to these recusal motions on similar bases, other judges of color. And this phenomenon persists, with litigants singling out for recusal motions judges who are of color, female, LGBTQ, and so forth. Which brings me to my conclusion. Visible diversity in every sector, including on the bench, is critically important, but not because judges of color and women judges necessarily will be empathetic and advance the interests of Blacks and women, as advocates of greater representation have argued since the Johnson administration. In some instances, I want to be clear, that might be true, but I don't see this as the best argument for representation. Inclusion is important primarily for the reason that Motley urged when she advocated the appointment of more women and of color judges. She said, these appointments reinforce American democracy and the laws of our land, which since 1964 have been premised on equal opportunity for all, regardless of race, gender, religion, and so on. Motley made this point, saying that inclusion of women and people of color on the bench should not issue because, quote, they would bring something totally different to the bench than white men. Instead, she said, inclusion builds confidence in judgment in government. It makes people feel that government is fair. Ultimately, then, Motley's ascent to the bench is a story of personal success that underscores an anti-discrimination imperative. The openness to lawyers from all backgrounds serves the purpose of paving the way for more diverse judicial nominees, because path-breaking nominees are role models, they're mentors, they're sponsors, they were inspiring. Certainly it was true of Judge Motley, who mentored a generation of women lawyers and professionals of color, leaving her imprints on some of today's most important public figures, including Supreme Court Justice Sonia Sotomayor, the People's Justice, who called Motley one of her favorite people and described how very welcoming she was when Sotomayor joined the same court in 1992. And of course, the first path-breaking Black woman judge laid the groundwork for the current Black woman path-breaking judge. And so I will end with Judge Jackson's salute to Judge Motley when President Biden announced her nomination to the bench. She said, "Today I proudly stand on Judge Motley's shoulders, sharing not only her birthday, but also her steadfast and courageous commitment to equal justice under law. Judge Motley's life and career has been a true inspiration to me as I've pursued this professional path. And I am so proud that my book, Civil Rights Queen, will introduce this great judge to new generations of Americans. Thank you.
That was wonderful. Thank you, Dean Brown-Nagin. That was a great recitation of Judge Motley's career and her background. Now we'll have our first commentator. Our first commentator is Professor Leandra Zarnal. She's associate professor in the Department of History and affiliate faculty in the Women, Gender, and Sexuality Studies and Jewish Studies at the University of Houston. She's a specialist in U.S. women's political, legal, and intellectual history. She has additional interests in media and archival studies and global gender history. She's the author of Battling Bella, The Protest Politics of Bella Abzug, published in Harvard University Press. It's a political biography of New York's firebrand, trailblazer, Representative Bella Abzug. Along with historian Stacy Taranto, she has also co-edited a collection, Suffragette 100, Women in American Politics Since 1920, published by Johns Hopkins University Press. Professor Zarnal frequently comments on women in politics and women's issues. She's a public historian. She seeks to bridge academic, activist, and community spaces in her work on and off university campuses. Let's welcome Professor Zarnal. Thank you so much.
Thank you, Dean Baines. It's a real joy to be here in celebration of Tomiko's masterful biography of Constance Baker Motley, truly a civil rights queen. And I take special pleasure in offering my comments tonight because Tomiko and I read each other's work in draft form as part of a feminist legal biography workshop that has now met for a decade before meetings at the American Society for Legal History. This brainchild of my mentor, Jane DeHart, biographer of Justice Ruth Bader Ginsburg, has been a welcome collective of legal minds focused on bringing women lawyers into the fold. And we've asked big questions. What exactly is a feminist approach to legal biography? And we've also focused in on hard ones too. So in Tomiko's case, how could one delicately and yet pointedly treat the uncomfortable truth that Mr. Civil Rights asked Motley to climb a ladder so he could inspect her legs during her first interview? I recall our vibrant discussion on that particular question and others as Tomiko shared as she navigated how to apply an intersectional feminist lens to a subject who did not define herself as such. So our workshop group dealt with some things that were light, but also many moments of sober discussion shaping our biographical projects as we navigated fresh territory. For the historical study of women in law really remains a relatively untreaded space. What we have shared is the insistence to carve out a place of consequence for women lawyers and judges as important legal subjects. As Tomiko unquestionably makes clear in her book, Introduction, Constance Baker Motley's world-changing accomplishments should place her in the pantheon of great American leaders. And I believe that this biography will in fact do that. So we worked simultaneously preparing our respective biographies of Judge Motley and Representative Bella Abzug, two major legal and political figures of the 20th century who also happen to be friends. I want to draw focus to their connections because it tells us a lot about the small world of women lawyers that they occupied in the mid-century. Both were daughters of immigrants, Bella Savitsky raised in the Jewish Bronx and Constance Baker born into West Indian roots in New Haven. And both were activists in high school and college. Constance expressed her conviction more politely, if ever resolutely, as Bella showed her dashing bravado early on in life. Both developed their political ideology in the swirl of the US Popular Front, which joined party members with unaffiliated leftists, New Deal liberals, and civil libertarians. This short-lived left liberal milieu stayed with the youth who participated in its student wing through organizations such as the American Student Union, so that was Bella Savitsky's, and the National Negro Congress, where Constance Baker gravitated. In these corners, these were heady times with heady talk about an anti-imperialist, Jim Crow-free, social democratic future. When Baker transferred from Fisk to NYU in 1942, Savitsky was just beginning her studies at Columbia Law School as one of 9 women accepted on scholarship to the school's accelerated wartime program of ladies in 4-H's, as one student put it. Bella Savitsky exited as Constance Baker was making her entrance in 1944. We know, and so it's, I think, interesting that even though their paths crossed just briefly at Columbia, they shared enough months and enough frustrations to become longtime friends. So we know so much about Rosie the Riveter, but how about those Rosies of the laws? Really, these women, and this is a best kept secret in the history of legal education, but women kept law schools afloat nationally during World War II. And we know that this was reluctant. In fact, Columbia Law Dean Young B. Smith lamented in the annual report, there will be no more able-bodied young men entering law schools until after the war. And much to his chagrin, women had to be admitted, in his words, to keep alive the tradition of the liberal arts and the study of the social sciences. So both Bella and Constance knew that they were not welcome. It was obvious from the W and the 0 and the O penciled before men on the door of the only bathroom female students used at the law school in those years. It was obvious when called upon in class only on Ladies' Day. And for Savitsky and Baker, law school was disappointing on another level. They found it to be, in Baker's words, an unmitigated bore, wholly theoretical, esoteric, and without practical application. And so for these former student activists, torts and constitutional law felt distant in application. Still, they rode the coattails of legal realism and learned that law is a social instrument for change. And in these years, they also met their husbands, thereby becoming Motley and Abzug. They pioneered egalitarian marriages, and they also became working mothers, bucking a white-centric domestic ideal of the time. So we could do more to tease out women attorneys and how they grabbed hold of this wartime wedge and really never let go. And so this really rich biography helps bring into further and fuller view how women lawyers carved out a space of their own in fledgling fields. Motley helping shape the civil rights doctrine, and Abzug working in civil rights alongside civil liberties and labor law. When advocating for their clients, they also advocated for themselves, and this was a point that we just heard, trying out arguments that would later become really the contours of feminist jurisprudence. And at Columbia Law, Abzug urged Motley, among other women on campus, to join her in lodging a collective grievance to challenge their unfair treatment. They opted to keep their heads down, but their hushed venting sessions in the alcoves of the library really helped them see and name the presence of institutional sexism. Vital law school friendships remain significant, helping women lawyers move forward into a male-dominated profession, not that different than their law school experiences. And so one can imagine the two on the phone together when they respectively started at Inc. Fund and also Witten Kammer. So Witten Kammer was a leftist labor law firm. And at Inc. Fund, Motley was excluded from weekly poker games and really had to take on a supportive role before she was given the opportunity to be a trial lawyer. At Witten Kammer, even though Bella Abzug really was under the tutelage of storied attorneys, one who helped draft the Wagner Act. When a silent partner, Lee Pressman, came back, he asked her to carry his briefcase to court, and she was passed over for a partnership. Also, clients voiced skepticism that Bella Abzug could be their lawyer. Here comes the Maisel. And we heard as well that was something that Constance Baker Motley dealt with as well. And so each dealt with what Brown-Nagin calls the gender troubles within their respective spaces. And so I think that it's really interesting for us to think about those connections and how women really supported each other through these friendships, and they really engage with one another. And I would say that in a lot of profound ways that we haven't really explored, we can see this. And so, for instance, I was really grateful to learn that Constance Baker Motley was involved in 1949 in Jackson, Mississippi, in the representation of Gladys Noel Bates, a science teacher who filed a wage discrimination suit against her district. And in those same years, Bella Abzug frequented Jackson, working on the appeal of Willie McGee, which was an important cause célèbre on the left specifically around criminal justice issues. And so I can imagine that they traded a lot of conversation and know that they were in frequent, calling each other frequently to talk through and work through their respective briefs and legal arguments and considerable legal imagination. So frequently on the phone together, they also talked about the death threats and the violence and intimidation that they faced, how difficult it was to leave their families behind in New York, and also, in the words of Bella Abzug, how it seemed all of democracy was at stake in that particular moment. And so I'd like us to just think about that, to think about the ways in which these women really, held each other up, and ultimately how the glass ceiling that they faced in the legal profession, particularly in the 1950s, ultimately encouraged both Bella Abzug and Constance Baker Motley to move from the law into politics. And so as Constance the First moved into the state Senate, then became the borough president and next a judge, it was she who urged the uncharacteristically unhesitant Bella Abzug along. In 1964, Bella Abzug wrote her friend Constance, "I'm certain that you will grace your office with much dignity, nobility, and effectiveness." She continued on, "Being a first is always both an honor and a burden. Since you've been fighting for all kinds of firsts for others, I'm sure you will do it bigger and better for yourself." Motley, in turn, offered Abzug the best example of what was possible, one lawyer to another. And so, unsurprisingly, 6 years later, Abzug too ran for Congress and won. And so that's where I'd like to leave the story, and Renee will pick up.
Thank you so much, Professor Zarnal. As a New Yorker, it's a fascinating story about two powerhouse women in New York City politics. I'd like to now introduce our next speaker. It's Professor Renee Kanaki-Jefferson, who holds the Doherty Chair in Legal Ethics and is a professor of law. She earned her JD from University of Chicago Law School. She teaches at UH, constitutional law, professional responsibility, and a seminar on gender, law, leadership, and power. In 2019, she held a Fulbright Distinguished Chair in Entrepreneurship and Innovation at Royal Melbourne Institute of Technology University in Australia. Professor Kanaki-Jefferson is an internationally recognized expert on professional responsibility and legal ethics. She's an author of 3 case books: Professional Responsibility, A Contemporary Approach, published by West Publishing; Gender, Power, Leadership, and Law, also published by West Publishing; and Legal Ethics for the Real World, Building Skills Through Case Study, published by Foundation Press. She's also written over 20 law review articles, published in prestigious publications such as the Fordham Law Review, Georgetown Journal of Legal Ethics, Illinois Law Review, Ohio State Law Review, Washington Lee Law Review, Washington Law Review, and Yale Law Journal. Her most recent book, shortlisted, Women in Shadows of the Supreme Court, has been called an excellent contribution and essential for anyone who values diversity by the Library Journal, and praised in many numerous reviews. She's appeared on TV and MSNBC, National Public Radio. She was named American Bar Association Legal Rebel, an annual honors program for the change leaders of the legal profession, and a member of Fast Case 50, an annual award that recognizes 50 of the smartest, most courageous innovators, techies, visionaries, and leaders in law. And her articles have been cited in U.S. Supreme Court briefs, by prestigious law reviews, and by popular media. Let's all welcome Professor Renee Kanaki-Jefferson.
Thank you so much. So I'm also thrilled to be here to be talking about the book that I have been reading, and I am hoping tonight to place it in context, both the book itself and then also a little bit more about Motley and placing her in context in some of the research that I've done. So this book, to be sure, holds a special place within the genre of judicial biographies. In some ways, it stands completely alone because no one has ever covered Motley's life in such a stunningly comprehensive way. the same time, it is a much needed contribution to a growing canon of works profiling women and minority judges and justices. Books like Evan Thomas's First on Sandra Day O'Connor, Corey Robbins' The Enigma of Clarence Thomas, Beyond the Supreme Court, the biography of Susie Sharp, Without Precedent. She was the first female justice in North Carolina. But far more valuable than simply adding another judicial biography to the shelves, this book exposes the intersections of feminist and racial justice struggles through Jim Crow, voting rights, and beyond, and really resonates with issues of the day. Constance Baker Motley should be a household name. As we've heard, she was the first Black woman appointed to a federal judgeship. Her career began by arguing 10 and winning 9 cases before the US Supreme Court. This was all happening at a time where professional spaces regularly prohibited women and minorities. Most of the women that I study in my research were initially denied their professional opportunities because of things like not having a bathroom in place for them. So here we are, well, not quite. Let's move a little bit, like 2 decades after Motley's initial appearance in the Supreme Court. That's when we finally see the first female Supreme Court justice in 1981, Sandra Day O'Connor. But even today, we are more than half a century after Motley first stood at that lectern. A female Supreme Court advocate is rare. During the 2020 term, 82% of the people arguing cases before the Supreme Court were men. And of course, it's now over 60 years after Motley climbed those stairs to the Supreme Court to argue her first case, that a Black woman will finally join the robed justices on the other side of the bench. I want to comment on 3 moments in the book that really struck me and have stuck with me. The first is incredibly haunting. It's when Motley packs up her 3-year-old toddler and husband, and they embark on a 17-hour drive from New York to Tallahassee. She's going to argue the case of challenging the University of Florida College of Law's exclusion of minorities. They're stopped in South Carolina. They stop to get gas. And the station attendant refuses her young son at the bathroom, won't let him use it. And according to the book, the incident, quote, infuriated Motley and only strengthened her resolve to combat racism and segregation, and also taught her a lesson. We learned to ask to use the restroom first. If the answer was yes, we would purchase the gas. If no, we would go on to the next station. This biography goes further than any other in portraying Motley for all that she was in these personal moments and how they intersected completely in her professional life. We know her as a lawyer, as a mother, and more. This includes her role litigating landmark civil rights cases. This was another moment that struck me. She describes an audience in Mississippi who arrives to see her argue her case as a circus, which I thought was quite interesting, since we heard a number of our Republican senators say they were not going to have a circus at the hearings that are occurring right now for Judge Jackson. And then the third moment that has really struck me in the book is Motley's advice on navigating the work-life balance that still plagues parents today. And she said, "I do not think that a woman should drown her talents when someone else can do a better job in cooking and cleaning. Pay a housekeeper," she advised, which also is really resonating with the hearings this week, where we heard from Judge Jackson herself saying that she doesn't know if she's always been able to strike that balance. This book succeeds in so many ways in providing this comprehensive description, really helping us all understand what it takes behind the scenes to attain the levels of success that Motley did. At the same time, and maybe this is somewhat paradoxically, in bringing to life the lesser known Motley, the book, it doesn't fully explore her counterparts who were navigating parallel paths at the same time. And I think because of that, it risks potentially compromising its ambition to paint a more accurate history of what has happened in this country by perpetuating the omission of overlooked stories. And this is not in any way meant as a critique of Dean Brown-Nagin, because of course, I mean, look at this book. If you haven't, it's heavy, it's jam-packed. And anytime you write a biography or a historical account, the author has to make calculated and sometimes difficult decisions about what to include and what to omit. And so really, I want to focus now on what I hope is a call to all of us for more of these stories to be told, to seek them out and encourage others to do them, and to take up the efforts that inspired the civil rights queen. And I want to just briefly share some of those parallel stories that were happening at the same time that I found in my research. One example is Amalia Kearse. She was the first Black woman to become a federal appellate court judge appointed by President Carter to the Second Circuit Federal Court of Appeals, in the seat that I think a very good case is made in this book should have gone to Motley. She gets only a very brief mention in a footnote, and that's probably where she belongs in context of telling just this story. But again, I think it's important to consider the parallel stories. And with Kearse, she was a graduate of the University of Michigan Law School, became the first Black female partner at a New York law firm, Hughes Hubbard and Reed. Her appointment by Carter made her not only the first woman to sit on a federal court of the Second Circuit, a federal court of appeals, but the second African-American to do so, of course, following Thurgood Marshall. Reagan shortlisted her for the US Supreme Court, the same time he considered Sandra Day O'Connor. He shortlisted her again when he put Kennedy on the court. Kearse was shortlisted again, or at least her name was floated, when things looked like they weren't going to go well for Clarence Thomas. And she was shortlisted yet again by President Clinton for the very seat that Breyer is now retiring from and will finally go to an African-American woman. So that's one story. I want to just briefly share a handful of others. And again, I think the reason why this is important to do is to help contextualize the efforts and think about why things worked in some instances and why they didn't in others. So just a few more to highlight. Jewel Lafont, who argued and won a case before the US Supreme Court in 1963. She was the first Black woman to graduate from the University of Chicago. She served for many years as a US attorney in the Northern District of Illinois. She graduated from Chicago the same year that Motley graduated from Columbia. And President Nixon was reportedly intrigued by potentially putting both of them on a Supreme Court shortlist, although he never officially did, although he did eventually put Lafont into the Department of Justice. Another woman, another Black woman who was navigating parallel spaces at the same time as Motley, Patricia Roberts Harris. So 1 year before LBJ put Motley on the court, he made Harris the first Black female US ambassador, and she would go on to serve in a presidential cabinet, the first Black woman to do so, as a Secretary for Housing and Urban Development and also Education under Carter. She would become the first African-American dean of the US Law School at Howard. And both Motley and Roberts appeared, I found this digging through archives when Nixon was considering putting a woman on the court. They both appeared on a list from the National Women's Political Caucus, recommending 10 potential Supreme Court nominees for Nixon to consider. And then the last story I'll mention, because we're in Texas, right? We have to talk about Barbara Jordan, who became the first post-Reconstruction African-American state senator in Texas in 1966. Now that's the same year that Motley takes the bench. And she was elected to the US House of Representatives in 1972. Her name found its way to Reagan alongside Motley's in a telegram I found from the president of Delta Sigma Theta when he instead selected O'Connor to be the first woman on the US Supreme Court. So these stories, I think, are important ones to tell, and there are so many more. Now, to be sure, Motley is deservedly the star of her own biography, but not including others who were engaged in similar efforts and not bringing these additional stories to light ignores significant lessons that I think are relevant and bear on the inequalities that endure today. And locating Motley's story within this larger framework offers a crucial counter narrative to the dominant history of women's entrance into professional life, which largely focuses on white women. Motley resisted the label of feminist, as did the other women that I just mentioned. And their understandable rejection of feminism, I believe, bears on modern dynamics where Black women remain excluded from many roles that white feminists have claimed. And so the way I'll close now is just to say, this book clearly could not be more timely and important, given that the nation is about to witness the confirmation of Ketanji Brown Jackson as its first Black female justice, and an honor that I think arguably deserved to go to Constance Baker Motley a long time ago. It's already been mentioned that they share a birthday. I appreciate this in part because as an interracial couple, I share the birthdays with, or my husband and I share the birthdays with Mildred and Richard Loving, of course, the couple whose Supreme Court case allowed for interracial marriage to be legal throughout this country. Maybe she'll form a club with me on these incredible coincidences, these threads that tie us together. It's important to tell these stories. Uncovering, memorializing, revising these histories, the incredible work that has been done in this book, it has to be an ongoing process, and we need more of it. As Motley herself said, and I learned this for the first time reading this book, and these are Motley's words, "We will not be leaving racism behind. The question, therefore, is clear. What do we do about it? The answer can only be found in the history of what we have done." So thank you, Dean Brown-Nagin, for writing this incredible history. And it's wonderful to be in conversation with everyone tonight about your extraordinary book.
Thank you so much, Professor Kanaki Jefferson. That was wonderful, as all the other commentators and presenters have been. I'd like now to introduce our next commentator, Judge Vanessa Gilmore. Judge Gilmore, in 1994, when she was sworn in, she was the youngest sitting federal judge in the nation. She's a native of Silver Spring, Maryland, and Queens, New York. And when she graduated from Hampton University in Virginia, her alma mater, she was the youngest member of the freshman class. Gilmore decided to undertake a career in law after she represented herself and won a minor civil lawsuit. She graduated from the University of Houston Law Center in 1981. In 1982, Gilmore began 13-year tenure at a Houston law firm known as Vickery, Kilbride, Gilmore, and Vickery, where she specialized in civil litigation. Gilmore also became an active member of the Houston civic community, serving on the boards of a number of civic and charitable organizations, including a term of president of the YWCA of Houston. She also became involved in Texas political arena while serving as counsel and teacher in the area of election law. Her civic activities outside the courtroom brought her in the attention of Governor Ann Richards, who in 1991 appointed Gilmore to the Texas Department of Commerce Policy Board, where she also served as chairperson from 1992 to 1994. Her appointment to that board made Judge Gilmore the first African-American to serve on this board, responsible for increasing business, promoting tourism, and developing job training in Texas. In 1993, she also served as chairperson of Texans for NAFTA. In this capacity, she worked regularly with diplomatic leaders, including the President of Mexico, to increase U.S. trade opportunities. Judge Gilmore was nominated to the federal bench by Bill Clinton in 1994 and became the first University of Houston graduate to be appointed to the federal bench. She's also the co-author of A Boy Named Rocky, a book for the children of incarcerated parents, and is an infrequent speaker on issues related to these children and their families. She worked on initiatives to help families with access to resources for the children, including development of a legal clinic at Texas Southern University. She's the author of 3 other books, including Saving the Dream, a fiction novel that Gilmore hopes will encourage other families and single parents to pursue their own dreams of parenting through adoption. She's a recipient of numerous awards for her community service. And let's welcome Judge Gilmore.
Good evening. Thank you, Dean, and good evening, everyone. I'm so appreciative of the opportunity to be here and speak with you this evening, but I am especially appreciative of the fact that Dean Brown-Nagin gifted us with this amazing biography of Judge Constance Baker Motley. My relationship with Judge Motley is of a personal nature. Obviously, there aren't that many African-American female federal judges. We are a very small club. And so I wanted to show my first slide, or maybe might be my only slide, depending on whether Luana got my other message about my other slides. But this is a picture that I wanted to share with everybody. That is a picture of Judge Motley in the middle, sitting in the front row, all in white, regal as ever, with all of the African-American female federal judges in the United States at that time, and that was in 1998. And to say that she was the one who paved the path for each and every woman that is depicted in this picture to become a federal judge is an understatement. She led the way, she blazed the trail, she opened the door, whatever way you want to call it. She is responsible for every woman that you see standing or sitting here in this picture that is depicted, that served on the federal bench in the United States of America. It is also, as Dean Brown-Nagin and as Dean Baines has pointed out, thank you for that slide. I don't know if we have any more of the pictures that I sent today, but maybe not. What I've spent my day doing, I started out my day actually watching Dean Brown-Nagin on NBC this morning as she introduced and discussed the nomination and the confirmation hearings for Judge Ketanji Brown Jackson. And then after that, I spent the entire rest of my day in the Senate chamber watching the confirmation hearing. The same Senate chamber that I sat in almost 30 years ago as I was sitting for my confirmation hearing. One of the senators that was there in the chambers today was Senator Grassley. He was chair of the Judiciary Committee when I went through my confirmation hearing. He is no longer the chair, but all these 30 years later, he is still sitting there. And it made me reflect and think about the fact that I was sitting in the same place that Judge Constance Baker Motley sat when she went through her confirmation hearing back in the 1960s. The chair of the Senate Judiciary Committee at that time was Senator Eastland. He was from Mississippi, and he still had a bone to pick with her about her work in desegregating his alma mater, the University of Mississippi. When we meet every 2 years, all of the African-American federal judges in the United States get together and we meet. We have an organization called Just the Beginning. It is a pipeline organization. And the purpose of the organization is to open the pipeline to encourage more students of color to consider the law as a path. And on one such gathering that we had in New York, we were blessed with the opportunity to see a film that had been done by Judge Motley's son about her life, and also a presentation, a reenactment, if you will, of one of her more famous cases, which was the James Meredith case, in which he sought to desegregate the University of Mississippi. I was so moved by the reenactment of that case, particularly since it occurred in the Fifth Circuit where I sit. The Fifth Circuit covers Texas, Louisiana, and Mississippi, that I came back and decided to dig and do some in-depth research and actually look at the court records related to her work on that case. We got quite an overview of the history of her work on that case from her son and from the reenactment that was done at the Just the Beginning meeting in New York. But I wanted to sort of fill in the gaps. I wanted to understand what her role had been in this very, very important school desegregation case. The Meredith case came right on the heels of Brown versus Board of Education, which was in 1956. James Meredith tried to apply to get into the University of Mississippi in 1961. He approached the NAACP Legal Defense Fund with the idea of having them represent him in his efforts to get into the University of Mississippi. Judge Motley recalled that when she was assigned the case by Thurgood Marshall, that he did it in his typical way, basically throwing the letter on her desk and saying, "This guy's crazy. He wants to go to Ole Miss. You're going to represent him. This is going to be your client." And so she took on the challenge of being the lawyer for James Meredith in his attempt to get into the University of Mississippi in the spring of 1961. He was rejected right away by the registrar, and by May of 1961, the lawsuit had actually already been filed. What I found when I went through the old records of that case is that Judge Motley worked tirelessly to represent her client. She immediately tried to get depositions of the registrar at every turn, every chance that she did to advance the interests of her client and to work on her case. She was turned down. Judge Mize would not let her take any depositions, but in turn, he let the lawyers from the other side take the deposition of her client, in which they belittled him, humiliated him, and attempted to discredit everything that he had to say. But she pressed on. She moved to have a temporary injunction hearing. She was treated no better by the judge in the temporary injunction hearing. An injunction hearing that should have lasted 3 or 4 hours, the judge concluded at the end of that day that it was going to take 3 or 4 days, and that was more time than he had. So he was going to postpone the injunction hearing until the end of the summer. The problem with that was that James Meredith was trying to get into the University of Mississippi for the summer term, July of 1961. The judge deliberately did that, trying to discourage her and trying to prevent her from being able to fairly represent her client. Finally, the injunction hearing was held in the fall of 1961, and the judge used every tactic to try to discredit her or her client, would not allow her to ask any questions. The transcript of the injunction hearing is rife with objections by the other side, all of which were abstained, and attempts by Judge Motley to advance the interests of her client, all of which were challenged and rebuffed by the court. Finally, the injunction she sought to enjoin them from preventing James Meredith from entering the University of Mississippi was denied. She appealed to the Fifth Circuit. And what was interesting was the Fifth Circuit immediately saw through what was going on with Judge Mize. And she was lucky that she had two judges, Judges Tuttle and Wisdom, who were part of a sort of cohort of judges that were infamously known in the Fifth Circuit as the Four, which were the 4 judges in the Fifth Circuit that voted in favor of most of the school desegregation cases. The moniker, the Four, was a slight to them, and it was a reference to the 4 horsemen of the apocalypse. But in any event, they immediately recognized that Judge Motley had been rebuffed in her efforts unfairly to try to pursue the injunction. They reversed the case, sent it back to the district court, and made the court have a trial on the merits. She lost the trial on the merits because of the same sort of shenanigans that was going on. The transcript is just rife with every effort that she made to try to represent her client. She was continually shut down by the court and by the defense attorney. She continued to pursue that case even though she lost. She appealed it again, and when it went up on appeal, she ultimately won in the Supreme Court, not until the summer of 1962. When she won that case and the courts ruled that James Meredith had to be allowed to enroll in the University of Mississippi, the governor of Mississippi pushed back and said he was just not going to let it happen. So every time James Meredith went there, he was attacked. He was not allowed to go into the school. She finally had to ask the President of the United States to get the U.S. Marshals to assist James Meredith in enrolling in school. It resulted in a riot and the calling of 15,000 troops to come and help him, the end of which was that 2 persons were killed, a reporter and some civilian, in the effort to get James Meredith admitted to the University of Mississippi. But she was able to make that happen. As a result, he entered the University of Mississippi. He graduated. He went on to Columbia Law School and became a lawyer and an activist, a social activist in the state of Mississippi. I want to also think that her work in that regard, in that significant case, was also laid part of the groundwork for the many school desegregation cases that Thurgood Marshall was later able to pursue in the Fifth Circuit, because in years that followed that, Thurgood Marshall tried a number of school desegregation cases in front of those same judges that had presided over the case in the Fifth Circuit when Judge Motley brought the Meredith case to the Fifth Circuit on appeal. Those judges, as I indicated, infamously known as the Four, ended up ruling on the majority of school desegregation cases that were decided in the Fifth Circuit in the 60s and 70s, desegregating many of the schools throughout the old Fifth Circuit, which at that time was all 6 Southern states: Texas, Louisiana, Mississippi, Alabama, Florida, and Georgia. And I think that the groundwork that she laid and the amazing work that she did before those judges was a part of the influence on them in terms of their willingness to rule in Thurgood Marshall's favor in many of the other school desegregation cases that followed after that time. I think that it is quite interesting to me that Dean Brown-Nagin pointed out that one of Judge Motley's most famous cases that she wrote about was defending her own right to be a judge. And I thought about that in the context of the hearings that I sat through today, listening to Judge Ketanji Brown Jackson defending her own right to be a judge on the Supreme Court of the United States. She obviously mentioned her birthday, her common birthday with Judge Motley. And she also mentioned what a mentor and a role model she was. I don't think that I would have had the pleasure of the ability to sit through those hearings today were it not for Judge Motley laying the path, blazing the trail for her to be able to have just even the opportunity to be considered for the Supreme Court of the United States. So I'm thankful to Dean Brown-Nagin for writing this book, bringing her to the attention of many. Some of us law nerds, obviously judges in particular, African-American female federal judges, of which we are a very small number, love Judge Motley and know her work and have studied her work. But I think that to give the world an opportunity to see the legacy of this amazing woman is such a gift. And I'm so appreciative of the opportunity to participate tonight. And again, so grateful to the Dean for writing this amazing book.
Thank you, Judge Gilmore, and thank you for your trailblazing career as well. So next, let's introduce our final speaker, who has a very personal connection with Judge Motley. So our next speaker is Professor Akeelah Falami. She has her JD from Columbia Law School and her BA from Spelman College. She's currently a professor of law at Hofstra Law School in Long Island, New York. She began her legal career as a law clerk to Honorable Constance Baker Motley of the U.S. District Court of the Southern District of New York. She then went on to practice an associate in the litigation department of Freed, Frank, Harris, Shriver, and Jacobson, LLP in New York, and then practiced in the technology transaction group of Morrison Forrester, New York's office. While there, Professor Falami developed her practice on a wide range of technology, intellectual property, new media, and internet-related issues, such as ownership, licensing, e-commerce, online contracting, and privacy. Prior to joining the Hofstra Law School community, Professor Falami served as an assistant professor of legal writing at St. John's School of Law. That's where I first met her. While there, she wrote on issues of exploring media consolidation and broadcast radio and its effect on American youth, and testified before the Federal Communications Commission regarding her findings. Professor Falami's scholarly interests include the intersection of communications law and media policy, and the regulation of speech and cultural expression, particularly hip-hop culture on broadcast radio. She teaches communications law, property, wills, trusts, and estates, as well as property law course in the law school's online Masters in American Law and Legal Studies program. Let's welcome Professor Akeelah Falami.
Hello, everyone. I'm so happy to be here. It is so incredibly warming, inspiring, and encouraging as a human being who is involved in this profession of ours to hear Dean Brown-Nagin discuss her comprehensive work on Constance Baker Motley. I know that it's been a labor of love, and I've been waiting in anticipation for its release ever since I heard about it. Thank you for this work, Dean Brown-Nagin. It is proving to be insightful and an engrossing read. I was enriched too by the incredibly insightful comments of others who have also spoken to Judge Motley, contextualizing her and her career. I've been invited to offer additional comments as a former clerk of Judge Motley, as Dean Baines just mentioned. I am honored to do so. Yesterday, Professor Lisa Fairfax of the University of Pennsylvania Law School offered personal anecdotes and stories as an introduction to the current Supreme Court nominee, Judge Ketanji Brown-Jackson. Watching Professor Fairfax offer her comments about Judge Brown-Jackson, I thought of today and the words that I could offer about Judge Motley. For a full year of my life, I not only sat at her proverbial feet and soaked in her legal mind, but also soaked in so much more than that, like how she moved, particularly as it related to me. I could talk about the many hours we spent drafting very intricate judicial opinions that turned on various areas of law, stemming anywhere from employment discrimination to patent infringement. But so many of her other law clerks could likely talk about that as well. Instead, I'd like to share the ways in which this force of a woman left impressions on me that extended far beyond our discussions about the law. Now, I can't talk to you fully about my experiences with Judge Motley without revealing a little bit more about my 20-something-year-old self, who was the rebel, who was tired, and who was annoyed. I went to law school frustrated and annoyed, and I came out of law school frustrated and annoyed, all the more so. By the time I arrived to clerk with Judge Motley, she was well into her 70s and still carrying a full docket of cases. Here I was, a new graduate of Columbia Law School who performed well in school, but who had definitely become disenchanted by the law and its continued gradualism in approaching inequality. I was the child of a woman 16 years her junior, a Gen X old school hip hop head, more familiar with the grittier side of urban America than the walls of Ivy League institutions in America, never mind the majestic inner beauty and workings of the United States District Court for the Southern District of New York, where Judge Motley served. In our conversations, yeah, we disagreed a lot, and perhaps that rebel and frustration with the law came out. I was deferential and respectful, but most definitely I had a voice, and she was more than open to hearing it. Sometimes she shrugged me off like an elder, and other times, most times, she engaged me. What I remember clearly was the impression that I was left with, which was that of being heard and seen in a way that was not always the case in law school. She often didn't necessarily agree with me in our conversations, but she came across as patient and always nudging. She commanded and walked in her authority, which was well deserved, if nothing else, but from experience. I knew that then, and I still know it now. In her chambers, there was a picture of her impeccably dressed with what I believe was a National Guardsman holding a rifle pointed upwards towards her head, and on what looked like her standing on the front stairs of the courthouse. In the picture, she stared straight ahead, stone-faced, as if there wasn't the tip of a rifle pointed near her head. None of my book knowledge on revolution, pursuant to my major at Spelman College, could compare to that image, or the many stories that she shared liberally with me and my co-clerk. Her stories were filled with details, impressively so. Maybe because she was writing her autobiography at the time, Equal Justice Under Law. One such story she shared with us was when she argued a case before an appellate court in the South, where one of the judges turned their backs to her, and she continued to argue it anyhow. Can you imagine? I don't recall now if that story ever made it into her book, but my co-clerk and I soaked it in incredulously. She would also share how she won every argument before the Supreme Court, save one that was reversed years later. That did make it into her book, for sure. It seemed like Judge Motley was loading my clerk and I with tons of stories as if to fortify us for the long and continued stride toward justice. For me, it seemed too that she took a special interest, nudging me on how to stay the course, without the course itself eating one alive while advancing in it and through it. I wasn't quite sure why then, but I still welcomed it. I would later learn that her cousin, John Huggins, which she talked about in her autobiography, was a Black Panther killed in a shootout with the police in Connecticut in the 1960s. Even pondering about Judge Motley's interaction with me years later, I can't help but know that she was trying to teach me something more than a critical eye towards legal analysis, but about how to engage the struggle, how to maintain and survive and even thrive, notwithstanding the engagement within it, which itself was, according to poet Audre Lorde, a revolutionary act in and of itself. A few years back, I attended an event at Quinnipiac Law School in Connecticut honoring Judge Motley with Charlene Hunter Galt, who was instrumental in desegregating the University of Georgia. Charlene spoke of a moment when she was 16 and unsure that she could go through with the desegregation plan being discussed among her, but with Motley, Judge Motley, Thurgood Marshall, and other civil rights attorneys. Charlene said she abruptly left the planning session to go sit in a car waiting outside. She would share the story of Judge Motley coming out to the car, sitting with her, guiding and mentoring her through the emotionality that comes along with these movements for justice. I know that woman of whom Charlene spoke. She never instructed me directly to do this or that. She nudged. Many of her lessons were informal, not direct, explorative even, down to the way she carried herself or walked in a room, and even down to how she interacted with her husband, Joel Motley. On the bench, she commanded authority. I recall the first time I heard her laugh within my first week of clerking. My co-clerk and I weren't sure whether to laugh as well. But again, back to my point with Mr. Motley, she had an entirely different demeanor interacting with him. It was accommodating and frankly, sometimes, actually oftentimes, deferential. When he out of the blue would announce and stand in chambers after having sat there hours and hours that he was ready to go, Judge Motley would get ready to, well, go. As Dean Brown-Nagin mentions in her book, they had an unconventional relationship. On the one hand, Mr. Motley stayed with their only son and raised him while she traveled the South with Thurgood Marshall, King, Medgar Evers, and others. What I witnessed was a gentleness between them, notwithstanding her being as present as she was. They were tender even in their bickering. But when Mr. Motley, who was the only one I ever saw drive them around, was ready to go, it was time. I would again gain access to this tenderness between them, well, particularly Judge Motley, when she invited me and my co-clerk to her summer home in Connecticut. It was a much slower pace filled with homemade lemonade and breakfast cooked by Judge Motley herself, with evenings spent sitting by the sea. And I'll end with what I think is one of the best of all of my stories. Judge Motley would invite me to her apartment in Manhattan a few Saturdays in a row. She would show me all of her memorabilia from travels, from being the Manhattan Borough President, the galas, receptions. Then out of the blue, she started pulling the very same dresses in the pictures out of her closet and asked me to try them on, saying, if they fit, you can have them. Of course, I pulled and sucked and tucked, as you can imagine, and walked out of her apartment with bags of regal attire. It was more than mind-blowing for a kid like me from around the way. It was tender. And it said to me from Judge Motley, take care of yourself. That struggle and community building is protracted. It takes strategy, planning, and more than just surviving and reacting. That we must find our humanity in it all, and even still retreat, retrench when necessary in order to heal, refocus, learn, and re-energize. I look back at those days in awe and gratitude. She was a formidable woman I am honored to have known. Thank you for giving me this opportunity to share these memories. I continue to hold them dear as they even still continue to shape me now. Again, thank you.
Thank you, Professor Falami. That was a wonderful reminiscence of Judge Motley. I'd like to ask all Dean Brown-Nagin and all other panelists to come back to have a conversation about this, about the book and about what we've just heard. So Dean Brown-Nagin, are you there? And Judge Gilmore? There we go. Great. So one thing that struck me with the conversation that was just, and I think it's what often people, I see young people ask generally, how does that happen? Like, you know, how does someone like Judge Motley occur, right? She, or any of these incredible, Bill Abzug, or any of these incredible women, or people generally, people of color, how does it happen that someone is such a trailblazer way before their time? Any thoughts on that, Dean Brown-Nagin?
Well, sure. I think it's a combination of personal qualities. She was incredibly intelligent and had a strong social consciousness, and also her context, her family, her culture, and luck. She was able to go to college and then to law school because a New Haven philanthropist offered to pay her way after he heard her speak at the Q House, as they called it, in New Haven. And she was a person of incredible fortitude, resilient. And there's this quote in my book where she says that she is a woman who would not be put down. She just would not stop. She just kept going, no matter the difficulties she encountered. And of course, there were quite a few. And I think it's important to consider all of those factors. You know, so many times people who achieve great things are written about as if, oh, it's only that they're brilliant, which she was, certainly, but there's so much more that goes into a life and where we end up in life. And a point of my book is to talk about the whole person and the whole experience.
Any other thoughts for those who may know her, or the other women, Bill Abzug, or the other women who were that Professor Kanaki Jefferson referenced?
I'll just jump in quickly and add to that list. So for sure, education. I mean, I think something that's that's shared in common with all of the women and minority women who were entering professional life at a time where they were literally excluded by the facilities. They did so because they had the opportunity to be educated. That was foundational. And then I think another piece is structural change. So the first woman who ends up on a Supreme Court shortlist is a woman named Florence Allen. It was in the 1930s. She has a judicial career because of the structural change, if you will. She was a suffragist. She championed for the right for women to vote, went all around Ohio convincing women they needed the right to vote. And once they got it, she turned around and asked them for their vote. And so that was a structural change. And then for Amalia Kearse, who ended up on the Second Circuit when really it should have gone to Judge Motley. In fact, if Judge Motley had been able to follow the path that a Black man at the time followed, her career really emulated Thurgood Marshall. But for Amalia Kearse, what's the difference? Structural change there too. When Carter became president, he literally changed the face of the judiciary, put more women on federal courts than any president before him. And he did it by signing an executive order and changing the way judges were appointed to federal courts through a series of commissions that were tasked with both being diverse in makeup and, importantly, requiring a commitment to diversity as one of the qualifications to be on the federal bench. Amalia Kearse served in one of those selection panels and ultimately was selected by it. So I think it's a combination of education for those early pioneers, a bit of luck, I agree with that too, but also structural changes that were happening at the time. And those are lessons that we can certainly still deploy today, even if we aren't all presidents penning executive orders.
I think also that we cannot underplay the value of resolute tenacity. And so, being able to imagine oneself in the room because no one is there already. And, I think that we can really see that in this particular case and sort of underscore that point.
Any others?
I have more of a question than an answer, right?
Okay.
And so I wondered to Dean Brown-Nagin, it's actually kind of a tough question to ask, but this is to anyone, particularly Dean Brown-Nagin. When she had mentioned in the opening comments today that Judge Motley was much more of a pragmatist, and I definitely experienced that by the time I got to Judge Motley later in years. And so one of the more painful points in clerking with Judge Motley is when she was talking at some event at NYU, invited by the Black law students. And so they came for her hard in terms of, because they found being pragmatic rather than being the self that she was before she became a judge slowed progress. And so I just wonder what your take was, and I think that's something you in your introduction and your opening comments here and in the book, Dean Brown-Nagin, you wanted to see how her commitment to social justice played out over the span of her career. And I wonder your thoughts on pragmatism. Her, in a way, did that, once you go in-house, for lack of a better word, does that that in and of itself, does that make you pull back, if you will, on that activism? And then some of that's the tension that the judge and I had when I first met her, right? But she was open to it. The reality of being the first Black judge, that it may be under more scrutiny if she wrote opinions that were a lot more forceful or what have you. So I'd love to hear your thoughts.
Sure, thank you for that. And thanks to you and all of you for your reflections on the book and broader context. I think it's important to consider seasons of a career. And, for the students who were coming at her, as you say, when she was pretty advanced in age, I wonder if they understood Cold War politics and how when Motley started out in the 40s and 50s, the NAACP lawyers were considered hard left. They were considered communists. Marshall and Roy Wilkins had to disavow communist in order to continue their legal strategy. And as I write about in the book, she was on a mission that required her to face incredible dangers and disrespect. And so I think it's important to tell the story about this life, in part to educate students who tend to only see the now and the here and tend to be very impatient and understandably. And then when she was in politics, the circumstances changed. She didn't call herself a feminist. Some might take issue with that, but she did feminism, right? So what's in a name? And then when she went on the bench, for sure, it's an interesting question. Is it that the judge became a pragmatist because she was on the bench, or is it that pragmatists are the ones who become the breakthrough candidates, right? And I think it's a little bit of both. When she was on the bench, and this is the last thing I will say, in the early years, when the Civil Rights Act was new and it needed to be implemented, she decided some amazing cases, landmark cases. And in addition, the case that I write about, the prison litigation case, was the closest to radical. It was surely controversial, and it also limited her promotion prospects. And it's just not something she had to do. No one would have been upset with her except for people who were on the margins of society if she had not taken the stance that she did, but she did. And she did it because she thought it was the right thing to do. It was a case that had her behaving in a way that was more similar to when she was in law practice and a gladiator. And so I think it's important to look at change over time with Motley and with everyone.
Do you think that, or how would you say that so far that the the nomination of Brown Jackson. How do you feel that resonates with Constance Baker Motley in terms of what you've heard in the hearings and that so far today and what we expect to hear?
Sure. Well, I have to tell you that when the nomination was announced, I was asked my thoughts, and it was in a moment when virtually everyone was just in the celebratory mode. And I said, buckle your seatbelts, because this is not going to be pretty. And it's not pretty. And I see continuity in terms of the focus on Jackson's practice background. Those who are opposed to her won't be able to keep her off the Supreme Court because of it, just by virtue of math, but it's there. And of course, all of the questioning about race and crime, there's absolute continuity in the kinds of arguments that are marshaled against African-American candidates for various professional high posts. And yet, Jackson is also in a circumstance by being there that Motley never was, and really was prevented from being because of her race, because of her gender, because of her practice background. And I will say, just in answer to the question or the comment about Judge Kearse decided not to speak to me about Judge Motley. And she's in a footnote, which is by virtue of her decision. And also what I say in the footnote is pretty substantive, and it is consistent with the sense that President Carter, she was preferable to Motley. It was an easier appointment. And so those are my thoughts. I think there's some continuity, there's some change. I'm happy that this moment is here. And it's been a long time coming.
There's a question from the audience from one of our alums, Rebecca Francis, says, she said, directs to Dr. Brown-Nagin, after listening to your episode of Code Switch and learning about Mrs. Motley's parents being Caribbean immigrants that distance themselves from American Blacks, this is Rebecca Francis's point, very typical among Afro-Caribbeans. My family does as well, she says. Does distance from the typical African-American experience help first-generation Blacks like Motley, Harris, Obama? Personally, I would posit that at the very least, it makes them more palatable to a wider, i.e. white audience, even with Ketanji Brown Jackson, her interracial marriage to family with the likes of Paul Ryan and Oliver and Wendell Holmes helps distance her and makes her more palatable. Any thoughts on that?
That sounds entirely plausible, I will say. It's not surprising that Barack Obama, given his background, is the first Black president. And it's not surprising that Motley is the first Black woman judge, as opposed to, say, Pauli Murray, who was less conventional. So these choices all make sense to me.
Yeah, good. Any other thoughts, since we are a bit over time, but any other questions or thoughts, last words anyone has? Well, I want to thank you. Thank you all. Dean Brown-Nagin, Professor Zarnal, Professor Kanaki Jefferson, Judge Gilmore, and Professor Falami. This has been a great conversation. Many, many thanks to all the donors to the Yale Rosenberg lecture series and the support. And this is a wonderful addition, Dean Brown-Nagin, to all the other illustrious folks that have come and spoken here. And this is such a timely conversation. We couldn't have timed it better, and we didn't really know when we scheduled it. Since we invited you a year or more ago, and you were working on your book, and you didn't, we're in the midst of a pandemic and whatnot. So it's amazing that it actually came to fore right now. So many, many thanks to all of you, and many thanks to our audience who are here. Many thanks to those who've stuck with us all this time.